Good morning. Welcome to another oral argument session of the 5th District Court of Appeal. With us today is Judge Nardella from our court and Judge Heather Higbee, sitting associate with us. We'll be hearing case number 20-504, Chautauqua Investment Group et al. Versus WP Underground Utilities, LLC. Appellant, we will reserve 5 minutes for rebuttal unless we hear otherwise. And just as a reminder, we are being broadcast live on YouTube, and this argument will also be recorded. Okay. With that, if you're ready, Ms. Solomon, you may begin.
Good morning. Sorry. Good morning. My name is Rania Solomon. I'm here on behalf of the appellants in this case. The Stark Investment Group LLC, Itzhak Stark and Ayala Stark. We are here on the appeal for this case regarding a failed construction project in which the court found that the lien impressed by the contractor, in this case, I will refer to the appellee in this case as WP, for the remainder of oral arguments. We have raised a number of issues in the appeal. However, for purposes of the time restrictions in oral arguments, I will focus my discussion this morning on two main issues in this appeal. The first main issue is the issue regarding the fraudulent lien, and the second issue is the damages issued by the trial court on the breach of contract claim. To start with respect to the issue on the fraudulent lien, the trial court misapplied the law in this case. The trial court essentially came to the conclusion that if the project, and adopted the argument by WP that if the project was substantially complete, the contractor, WP, had the authority to lien for the entire amount of the contract, regardless of whether the full amount of the work was completed or not. The court basically adopted WP's argument and did not look at the standard in 713.31 subsection 2A. The subsection 713.31(2)(a) defines a lien in 3 ways. If a lienor willfully exaggerated the amount of the lien for which the lien is claimed, or if the lienor willfully included a claim for work not performed or materials not provided, or if the lienor compiled the claim with such willful and gross negligence as to amount to a willful exaggeration. The court looked at only the contract price, and basically because the work on the project was dictated by a contract which had a definite price, and that the lienor in this case, WP, did not only lien.
For the purposes of this discussion, can we kind of inverse the order on the statute a little bit? So rather than focus on whether or not there was additional cost lien for that were either not performed or not contracted for, can you focus kind of on in your view, why the trial court erred in determining that it was not either willfully exaggerated or a matter of gross negligence in this case?
Okay, yes, absolutely. If a lienor includes in the claim of lien amounts for work that the lienor knows that was not performed, as in this case, the lienor liened for work not performed and services not provided. The lienor in this case liened for bonds that the lienor admitted at trial, before trial, that the lienor never obtained. At a cost of,
is it your argument that as a matter of law, anytime those additional or non-lienable items are included in claim of lien, that it is per se fraudulent? or do we
Yes.
need something more?
By definition, under 713.31, 2A, subsection 2, the lien would be fraudulent. The question then becomes whether there is an exercise of good faith on the part of the lienor when they are impressing the lien on the property. And so if the lien provides for work not performed, admittedly, which in this case, there is no dispute regarding whether or not the work was not 100% complete, the case law provides that it would be a fraudulent lien, as in the case of Viola Company v. Gomes. The contractor in that case made improvements to certain pieces of, residential property, filed a claim of lien in the amount of $57,675, which was the remainder of the full contract price. The owner filed a claim for a fraudulent lien.
Isn't it true though in that case that the contractor testified that there was essentially a $27,000 discrepancy there?
Absolutely.
And that it was knowing? And so how do we factor in here that the testimony in this case is not that there was a knowing, in that case, almost 50% discrepancy and a significant sum of money? Isn't there evidence here to support a finding that, one, that the contractor believed in good faith that he was 100% complete, although there was punch list items remaining? There's evidence to support a finding that there was essentially a $7,000 difference, even if you, on a $100,000 contract, if you factor in the work that wasn't performed. Aren't those all conclusions that the trial court could have reached on this record?
That is why I am saying that the trial court erred in applying the wrong standard for a lien. What the court needed to find is whether or not the lien was impressed either in good faith, which I'm not sure how the court could have come up with that finding, because
wasn't that finding explicitly made in the final order?
There is no finding regarding good faith in the final judgment. And that is the issue that we have with the trial court's ruling. The trial court basically—
The final order says WP did not willfully and intentionally exaggerate the amount in the claim of lien because the amount in the claim of lien was contract price in addition to the agreed upon change orders. So
Correct.
How is that finding regarding willfully and intentionally not exactly what the trial court was required to determine based on the plain language of the statute?
Because the issue is not whether the contract price, it's not whether the lienor lien for the contract price. The issue is whether the lienor included amounts that were not performed. By definition, that lien is fraudulent. The issue is going to be whether the lienor knew or should have known that they didn't perform those items for which they charged. And they knew. There's no contradiction to the lienor's knowledge. They knew that they didn't complete the project. They actually sent emails to the owner after they were off the project saying, we have 3 more days left on the project to complete.
So am I understanding your argument that the finding regarding willfully and intentionally is insufficient? In other words, the trial court would have been required to make a finding that is not currently in the final order in order to comply with the statute?
Correct. The trial court, because the
okay. So was that specific argument raised in rehearing? That the trial court failed to make a finding that it should have included in its final judgment?
The trial court, the final judgment, there was a rehearing on the final judgment to clarify the findings of the court as to who the judgment was rendered against, because I believe the initial final judgment just basically found the appellants liable and just without essentially dictating on what cause of action. And so in this case, the trial court didn't make a finding of good faith or lack of good faith. If you can interpret, I guess, that the court must have found that the lien was placed by the lienor in good faith, but I'm not sure how the court could have reached that finding based on the fact that there were.
I'm more concerned right now about the preservation issue, because if your argument is that the trial court should have made a different finding, that it's not included in the final judgment, doesn't our case law suggest that that needs to be raised in rehearing in order to be preserved for appellate review?
Well, we did clarify, we did do a motion to clarify the final judgment.
Looking at that, and I see, paragraph 3, to ensure WP maintains its rights to enforce the judgment, the court should modify the final judgment to specify the damages awarded to each claim. It should contain language indicating the damages are joint and several, etc. It all appears targeted to damages, the motion for a hearing. So in terms of preservation, I'm wondering where in the record that issue.
The issue though, in order for the court to find that the lien was not made, was not fraudulent, the court had to find that the lienor put the lien on, either mistakenly believing that they performed all the work when they didn't, or that somehow there was good faith in their belief that they should have put a lien, or that the work was completed, all of the work was completed. There's no evidence here that all of the work was completed. And therefore, the only way that this lien isn't fraudulent is if somehow WP thought that the work that they did was 100%. And
isn't that statement in the record that WP thought that they were 100% complete?
That they did make that statement, but I'm not sure how that statement could be made in good faith when all of the evidence that was submitted at trial contradicts that statement. There is nothing that shows that the project
does that require us, in order to find that statement is insufficient to support a finding that any misstatement was not made willfully and intentionally, wouldn't that require us then to reweigh the evidence? If there is evidence in the record to support the trial court's finding, obviously we are prohibited from reweighing the evidence. So how do we determine, as a matter of competent substantial evidence, that evidence was insufficient?
The record is clear that there's no way that the project was 100% complete. The court actually makes a finding that says, even though the project was substantially complete, it all was not 100% complete. The lienor in this case leaned as if it was 100% complete. And that is not what the lien law allows. If the lienor knew that the work was not 100% complete, the lienor had an obligation legally to reduce the amount of the lien by the amount of work unperformed. And that's not what happened here. The lienor put a lien on the property for the full amount plus the change orders. And that's what makes the lien fraudulent, is because the lienor included amounts that were never performed and that they would not have been entitled to collect. Because the lien was fraudulent, it left no remedy for the appellants in this case, except to basically dispute the lien and be in this lawsuit and file the appeal in this case, because the court relied on the fact that it wasn't willfully exaggerated. But remember, because the construction lien law allows a lien to be fraudulent, not just on one way, but 2 and 3 ways. So in this case, the second prong of 713.31 2A was met by the appellants. We proved that they did not, that the WP included work that was not performed, and therefore the lien was patently false. And in every case where the courts have seen that the lien included work that wasn't performed, and I'm not saying that there was a dispute over the level of completion. There's a difference between a dispute over the level of completion and the work is not being complete and yet charged. Okay.
There's several cases though where that wasn't the case. I'm looking at a second DCA case from 2011. Although the claim of lien included 2 items that were not lienable, there's no evidence to support the trial court's finding that it was filed in bad faith. Even though the trial, and this is a third DCA from 2008, even though the contractor included items in the lien that it should not have, such as overhead and profit, the court determined after observing the demeanor of the contractor's testifying witness that the items were included by mistake, et cetera, et cetera. The cases go on and on like that. And isn't that exactly what happened here? The court recognized there was items lien that should not have been. But after taking the testimony of Mr. Patton, the court determined, based on his testimony and the surrounding circumstances, that was not done good faith, willfully, intentionally, whatever terminology you want to put on it.
Yeah, in those cases, the courts are recognizing that sometimes there are overhead that is being charged. There are some charges that should not have been included. But this is not the case where you have work that was never performed and that was included in the lien. So those cases in which there was work that was not performed and it was the price of which or the cost of which was included in the lien, the courts have found that the lien was fraudulent. If you look at Scott v. Rolling Hills place, and that's a 5th DCA, 1996, the architect in that case, the court found that the lien was not fraudulent because the architect had designed the plans completely and fully, but did not actually deliver the plans to the owner. And the owner filed a lien saying that it was fraudulent. You had not completed the work. And the court said, wait a minute, they did complete the work. They just didn't give you the invoice. This is different than what that case provided. There is no dispute regarding the work that wasn't performed and that was lien for the work that wasn't performed or the bonds that were not obtained. $3,000 is the cost of the bonds and they were put in there. All WP had to do was reduce the lien by the amount of work that wasn't performed. Take the 10%.
You're into your rebuttal if you want to reserve the remainder.
I'm sorry? You're
into your rebuttal if you want to reserve the remainder.
I will reserve the remainder. Thank you.
All right, thank you. Ms. Cregan?
Good morning, Your Honors. My name is Jessica Cregan. I represent the appellee WP Underground Utilities, LLC. I'd start off by saying, and I put it in my response brief, that this is a case where the appellants are attempting to ask this court to retry the case on the facts. These were factual issues that were in dispute. The court did its job in a non-jury trial by weighing the evidence and the credibility, and the standard for review by this court is the competent substantial evidence standard. And I cited to a case, Lonergan v. Estate Budahazi, that defined exactly what competent substantial evidence is. Competent goes to the admissibility of the evidence. There is no argument being raised by the appellants concerning the competency of any evidence. Every piece of evidence and testimony that the appellants attempted to enter into this trial was admitted by the court. So the only standard portion that this court should be considering is whether the substantial portion of the substantial evidence was satisfied. And in the Lonergan case, the definition of substantial requires that there be some, more than a mere iota, of real material, pertinent, and relevant evidence, as distinguished from ethereal, metaphysical, speculative, or merely theoretical evidence or hypothetical possibilities, and that evidence has definite probative value that is tending to prove each essential element of the offense charged. The court went on to say that circumstantial evidence does satisfy the competent and substantial evidence standard. Direct evidence is not required. Further, the court went on to state, and it was a 5th DCA case, that the court is not going to, this appellate court is not going to step into a trial court's job of weighing the evidence. The trial court has a position of being able to not only hear all the evidence, but see the manner in which it's presented.
What is your response to the argument that essentially it was undisputed that the work was not 100% complete? Clearly had not finished the job, did not obtain bonds as contemplated by the contract, and those funds were included as the overall contract amount. And so it could not have been anything other than either gross negligence or willful exaggeration to include the entire contract amount in the lien.
I disagree with that representation. The statute 713.31 subsection 2A, there is a willful element. The mere inclusion of something for work not performed is not what the statute says. The statute says willfully included work not performed. The case law is clear. Willful requires a trial court to examine the good faith or bad faith of the lienor. That is in the trial court's discretion. It goes to the weight and credibility of the evidence. And the court, I'd like to cite to the Castillo v. Sweetwater, it was a 5th DCA case. And in that case, there was, again, a willful examination was what the court was going through. And the order that came out in the 5th DCA's evaluation, the trial court made a specific finding that the lien was not willfully exaggerated, which is what we see in this case. The court made that specific finding. Further, there was an evaluation that there was no competent or substantial evidence that the plaintiff's lien was filed in this matter was not submitted in good faith. Further, the trial judgment said in the final judgment that the court finds the plaintiff's lien was filed in this matter was not fraudulent. Those line up to exactly what the trial court found in this case, that it wasn't willfully exaggerated. I'd like to remind the court that the fraudulent lien was a claim brought by the appellants. It is their burden to prove that the bond was included willfully. It is not simply just a mere inclusion. The statute does not say negligently included. There is a heightened standard for the inclusion of that. And the fact is that the court in its evaluation factored that in because there was a $7,000 deduction in what was rewarded. The testimony is clear, the bonds were $3,000. The court can clearly understand that the bonds were then removed from that. There was no bad heart situation found in the WP case. And I think that is clearly reflected by the court's final judgment in this case.
Can you speak to the damages that you believe, whether the damages that were awarded you believe are accurate and the basis for the trial court's assessment of the damages?
I think that the basis for the assessment, the court ultimately in this case ordered that $80,219 in favor for WP as to both the lien and the breach of contract claim. As far as, I don't believe that there's any case law that requires the court to make any type of specific findings concerning how they derived that number. The number, I think the court laid it out in the factual findings that the contract price was $107,519, and it lays out specifically how it derived that amount. The court took into account that there was a $20,000 payment. Therefore, it remained an outstanding owed of $87,159. The court ultimately awarded the $80,219. So with that difference, I think that there is taking into account the $3,000 for the bonds. In addition, that provided $3,940 for the punch list items. There was the testimony provided was clear punch list items. WP was terminated before punch list items could be addressed. The evidence that, and I think that the court took into account those punch list items.
Counsel, can you address the application of interest in this case and whether or not, go ahead.
I'm not sure. I didn't want to cut you off. There was another part to that question.
Well, there was an argument by appellant that it shouldn't come into play because there wasn't an invoice sent, although there are some pay applications in the record, and I was hoping you could address that.
I think a pay application and invoice, whichever one you want to call it, tomato, it is what it is. I sent you a pay application invoice. I'm asking you to pay this balance. I think that is in fact an invoice. The contract does specifically provide for interest, and it provides the amount 18%. This was a contractual amount that was agreed upon by the parties. So that is under 713, the statute does allow for anything contained within the contract to be awarded under a lien. And so in this case, if there was interest included in that, then it would by all means was proper under the statute.
Going back to the fraudulent lien for a second, appellant made the point that or argued at least that there are no cases, as far as she's aware, that where a court has determined that including work that was actually not performed as opposed to items that are not lienable, such as overhead and profit in the case that I discussed, was not fraudulent. What would you say is the case most directly on point to your case or most similar? And do you have any cases that you can cite to where the lien included work that was not performed, yet the court did not determine there was a fraudulent lien?
I think that the work not performed, I think, goes to those punch list items. I think that the case most similar, because it is such a fact specific issue concerning the willful. I don't necessarily know if there's one case that is just this case that lays it out. But I think that the case law that I cited, and I think the Castillo case really talks to it, is that it has to be, it's a trial court's determination as to that good faith and bad faith element. And willful is a burden that the appellant had to prove at the trial level, because that was their cause of action. It was an affirmative defense to WP's amended complaint, but it was in fact also a cause of action raised by the appellants in their own counterclaim. So I think to that, I go back to say that it is based on the totality of all of the evidence that the trial court heard as to whether there was good faith or bad faith present, and it's bad heart, and there was no indication in the record that WP had that bad faith. That was a burden for the appellants to prove, and it is, if they don't prove it, then by definition you have a minor mistake. And I think that goes back to that good faith and the amount of what we were talking about. In cases in which there was a willful exaggeration, we are usually, those cases we're talking about some exorbitant amount. The case where the contractor included numerous items, $27,000 of items not performed, that was half of the contract that was part of it. In this case, we're talking about $3,000 of a $107,000 contract, not even barely 2% of that contract. So I think that goes back to that minor mistake being made. And I think the appellants failed to carry their burden at the trial court level, and the competent substantial evidence and the specific findings of fact line up to the Castillo case. The court found that in this case. So there is, again, the appellants failed to meet that burden at this level too, and I don't believe that the court should overturn the trial court's ruling. Is there any other questions?
Anything else?
Continue on.
I have a quick question. So this case involves 3 parcels of land, and it's the position of the appellant that all 3 parcels of land are owned by Mr. and Mrs. Chautauquas, husband and wife. The record includes 2 quitclaim deeds, and the legal description on those quitclaim deeds are a little difficult to read. So is it the position of the appellee that all 3 parcels of land are owned by husband and wife?
Yes, I don't believe that there was any testimony to the contrary that they were separate or owned any different way. And I guess just to provide a court just a little bit more background, is that it's almost just one really long piece of land. If you look at some of the exhibits included, the property appraisers printout, so you can kind of see what those parcels look like. And it's just a long stretch of land. And there's a house that basically sits almost in the middle. There is no distinguishing factor of how these three parcels are. It's operated as just one piece of land. So there is no separation or of any nature.
Anything else?
I think I would address, unless there's any other issues with the court, I would just reiterate that I think the standard of review for this case is the competent substantial evidence. I think the record is clear. I think this trial court, I think, went above and beyond in issuing this final judgment, made it very clear that she took into account all factors that were presented by the appellants throughout the course of the trial. And there is no error on the trial court's part. If anything, the appellant failed to meet its burden. There was a counterclaim raised that included everything that the appellant is presenting to the court today. That was a counterclaim. They had a burden at trial. They failed to meet it. The court did not ignore any evidence. It was all addressed in the amended final judgment. And I think that the amended final judgment, the trial court's rulings, should be affirmed by this court.
Thank you. Ms. Solomon?
Yes, first, I believe the appellee raised the bad heart, that this is, there's no evidence at trial regarding WP's bad heart motive, I guess, if you will, for putting on a fraudulent lien on the property. The lien law doesn't require a showing of a bad heart or some sort of malicious motive. It does require that for punitive damages, which, by the way, is an element of damages under a fraudulent lien. What the lien law requires a showing is that the lien is put on willfully, meaning I didn't make a mistake as a lienor, and I thought that I had obtained bonds, but I didn't actually obtain a bond. This was a willful act by WP to get not only the contract price, but $8,180 above the contract price. And that's why they put the lien on, is to obtain payment. It was a willful act. It was an intentional act. They knew they did not perform all the work that was required. They knew they included work that was not performed in the lien. Besides the $3,000 bond that they did not obtain, they also included the cost of 11 meter boxes that they did not install. They did not provide to the property owner. They also liened for the cost of the work for the locator balls being located on the pipes. They acted as if they had done all the work on the project, and they did not. And that's what the fraudulent lien law entails. It puts the burden on the lienor to identify and to know what they performed and what they didn't perform. And if they didn't perform all the work, then they have an obligation to reduce the amount of the lien accordingly. In the cases that I believe Your Honor, Judge Sasso asked about, the Delta Painting Inc. versus Bowman, and that is in 710 Southern 2nd 663.
And you're out of time now. If you could just wrap up in the next 30 seconds.
The lien was fraudulent based on the cases that we cited, the Delta Bowman case, the Medellin case. It was fraudulent because it included amounts that were not owed, and it was done intentionally and willfully. And the level of damages that the court prescribed, I will defer to the argument that we raised on appeal, that it was wrong for the court to rely on the measure of damages because it didn't account for work that was done.
Thank you, Ms. Solomon.
Thank you.
Thank you both. We'll be in recess.